Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Today I'm looking at a book which has come to us from Oxford University Press. We've reviewed it in the past, a few years ago now, but the book has now appeared in a fourth edition. It's Principles of Medical Law. That's the title we currently have for it. Been edited by two people, Judith Laing and McHale. And the consultant editors are Serene Kennedy, who will be known to many of you, and Andrew Grubb. The book, as I say, comes from Oxford University Press, and Elizabeth and I talked about this book because it is for a specialist audience without any question of doubt, and we gave it the review title of following: Definitive Help with a Very Complicated Subject. The Principles of Medical Law is out now in a new fourth edition. Well, let's have a look at the book first of all. It's a heavy book and a hardback. There's the front, red cover, and there's the spine. You can't see, there's nothing on the back at all. It's a heavy book, as I say, and it runs to 1,200 odd pages. Now, the actual index is by paragraph numbering, as you can see there, and it's a substantial index. It covers a large area, and of course there's the index itself, and then at the back you've got a number of appendices, Appendix A and B. Now, at the front of the book, you've got the main front cover there. And then you've got the basic information from Oxford University Press. Then the very long list of contributors. A huge number of people are involved in the production of this. And many of them will be known to you because, as I said, it's a specialist area. Now, the two editors, the actual consultant editors, Kennedy and Grubb, have produced what is a very useful foreword, which sets out what's in the book at the moment. Then there's a preface, of course, to go with it, which sets out what's changed since the last edition. The preface was written in January 2017, and I'm recording this in April, just before the general election. Now, the summary of the contents is set out in the various parts, and you've got the names of the individual contributors to go with the parts. There are 7 parts in total and 22 chapters, and then you've got a much more detailed set of contents which covers all of the detail in much greater depth. What you've also got is, I think, a very useful link with the index, so you should find things easily. Then, of course, you've got a large number of cases which are covered there. Then you've got the table of legislation after that, in other words, the statutes. Then you've got a table of statutory instruments to follow that, and then you've got treaties and conventions, which of course are also very useful to know about. And then you've got tables of European law, that's still there, and of course you've also got, in addition, a number of legislations from other jurisdictions. Again, that's coming in more as the subject matter and everything we do, it becomes global in its approach. Then you have part 1, the various parts we've just set out. Then you have what you've got is a heading. Then you have a short index for the chapter. And then, as you can see on the side, you've got paragraph numbering and you've got footnotes at the bottom. It starts off with the structure of the National Health Service. And then, for instance, you've got, as you go into the book, defences for causation and so forth, and then running all the way through a whole range of things. Medically assisted reproduction, marriage and civil partnerships, all that information. There's a huge amount of information. As I said before, word of warning, this is a specialist area, and therefore people who are involved will know about this book. But if you come to it relatively new, it's a book which I think you will find helpful. It does presuppose that you have some knowledge of the subject matter, because anything you do, as I certainly found this, when I did the bar exams many years ago now, we used to have a little glossary of terms which I found very helpful, because for me, I did not know a great deal about medical terminology at that time. I had to know a bit about it because part of our course involved writing an opinion and knowing a little bit about personal injury. So therefore, and of course in pupillage I did the same thing, so therefore it is very useful to have some grounding of the information available. So what do we say about the book? Because medical law itself is an interesting area, and as I say, it is really highly specialised. it's a complicated subject for you to get your head around, especially. And that is actually the case if you are a practitioner who specialises or intends to specialise in what has become a rapidly expanding area of law known as medical law, which can encompass quite a lot of things, of course. Fortunately for you then, Oxford University Press, if you are going to embark on this interesting course, they have brought out a new and completely updated edition of Principles of Medical Law, this one here. It's long regarded as the definitive work, I hasten to add, in this area, and the new edition, which is the fourth, been completely updated to encompass the new developments that have transpired since the last edition came out in 2010, so there's a 7-year gap. And a lot of things have happened, of course, in that time. Now, writing in the foreword, Ian Kennedy and Andrew Grubb recall a day when medical law was a relative newcomer. I'm afraid I do too. I'm getting a little bit older. Obviously, as a relative newcomer in terms of legal specialties. Now, in their words, it barely existed such that you were free to make it up as you went along. Alas, that was the case. It is something of a sobering thought, however, that day has long gone. Nevertheless, they add, this work always had in its genesis an ambition to serve academics, practitioners and judges alike. And with its depth of scholarship and coverage, has since maintained a claim to have fulfilled that ambition with style, and some style indeed, I would hasten to add. And one of the reasons is because you've got such a large number of people who are directly involved as the contributors, and I think that does help, because you've got all of the wisdom of all of the individuals being brought and pulled together in this new work, and I think that does give it a certain cachet. Now, as medical law is dependent on specialist practitioners, the emergence of a new edition of this classic text is fortuitous, especially so when the National Health Service is coping with an ageing population and all the implications thereof, and of course budgetary ones. And even when even the man in the street can tell you that the government has set aside billions in funding for things such as medical litigation, which has been a considerably growing area for a long time, and that covers a whole range of different problems to cover all of that, the sort of bill that the NHS may have to face. Obviously, private medical practitioners are, of course, privately insured, but there's still a large amount of litigation in this area. And developments such as these broadly coincide with what the editors refer to as the fundamental rights-based approach in the courtroom. As, to cite only one example, doctors are made aware of a duty to provide information to patients. And of course we have changed, I would suggest, in 40 years very substantially in our overall approach. The way the NHS operates and everything else, everything has changed considerably, and therefore we have to take account of that. And another area of concern, of course, includes the end-of-life care and the determination of mental capacity, both of which are growing areas of interest to to litigators. Now, given the complexity and enormous scope of the subject, the book itself is a collaborative work of a distinguished and expert writing team, as I've indicated, a large number of people, 2 editors, 2 consultant editors, and upwards of 16 other contributors. Now, across almost 1,300 pages in total, 7 parts and 22 articles, which make up the chapters, the book offers detailed analysis and commentary, on a formidably broad range of other issues, from the organisation and regulation of healthcare to actions arising from birth, to consent to treatment, to the regulation of medicinal products and medical devices, and of course much more. So you see there's a huge range of stuff that's been actually covered here. And here is a field fraught, of course, with uncertainties, and these 2 are dealt with in a measured, frank and analytical manner. And I think that's again helpful because, as we said earlier, a few years ago, it really wasn't. It was a relative newcomer, as they said, the 2 consultants, editors said. And of course we have to bear that in mind. It's relatively new in terms of this scheme of things. Now let me conclude by mentioning a few other things about the book. I think of additional and indeed vital assistance to the practitioner are the 90-odd pages of tables of listed cases, legislation, essays, treaties, conventions, European law, legislation from other jurisdictions. And it's helpful too that a text this size is easy to navigate with numbered paragraphs, a detailed index and a table of contents and extensive footnoting. And I did like the chapter little short indexes for the chapters, which again should make it much easier for you to find things. So given the pace of attitudinal and policy changes in this field, this book provides invaluable assistance to the practitioner, charged with providing authoritative and carefully considered advice to clients. And therefore, I think it's a welcome addition to the well-stocked and up-to-date practitioner library. Excuse me. The publication date is cited as at 2017, and as I've indicated, it's the new edition, the fourth edition, so some 7 years between the two. Here's the book again. There's the side of it. Let's just open it in the middle. You can see here, this is Consent Adults Who Lack Capacity. So this is care of those lacking decision-making capacity. So you've got Court of Protection Matters, the jurisdiction of the High Court covered. You can see you've got your paragraph numbering on the sides there, and you've got all of the footnotes and a lot of detail all the way through. A lot of reference to, in this case, the Mental Capacity Act, and you've got all sorts of other points. For instance, you've got here best interest and the statutory checklist. So you've got everything that you should immediately be looking for, and you've also got very useful extracts from major judgments. There's one there, for instance, from the Supreme Court in case of Aintree. So all in all, this is a very, very well put together book. It is, as I said, an area which is expanding, and I see no reason why it won't expand further in the course of time, litigation being the way it is. But in the meantime, I'd like to thank OUP for taking this book and continuing to publish it with new editions and updating it, and to all the people involved. You make our lives so much easier by producing this work, so a very big thank you to all of you. Bye-bye.